It's 1991, Menorca, Spain. What was supposed to be a relaxing 14-day island getaway is about to devolve into a logistical and legal nightmare. It started with a standard commercial transaction. The plaintiff booked a vacation for himself and his girlfriend, explicitly expecting a room with a double bed. But when they opened the door, they didn't find a double bed. They found two totally separate single beds. To make matters worse, those beds were resting directly on slick, uncarpeting floor tiles. It was a highly volatile environment for any movement. What seems like a minor interior design choice actually set the stage for an international legal dispute over physical intimacy. On the very first night, a distinct mechanical failure occurred. At the slightest application of movement or weight in the center, the unattached beds would slide laterally apart. According to the plaintiff, the sliding beds entirely destroyed their, quote, harmonious sleep and intercourse experience. Frustrated by extreme annoyance and a loss of recovery value, the traveler sued the agency. He demanded a 20% refund on his 3,078 German mark vacation. When you pay thousands for a specific experience, who is legally at fault when the physical realities of a room ruin your most intimate plans? The case landed before the local court of Mönchengladbach, which surprisingly decided to take this grievance completely seriously. In their ruling, the judge first played out a glaring evidentiary gap. The plaintiff failed to provide any detailed explanation of what specific sexual habits legally necessitated a firmly attached double bed. The court then offered a dry rebuttal on human biomechanics, noting that there are several generally known variations of intercourse that can be successfully executed on a single bed to the satisfaction of all parties. In other words, the travel agency didn't physically prevent intimacy. The physical constraints simply required the plaintiff to adapt. But let's assume the plaintiff absolutely required a double bed. Does two single beds legally constitute a Reisenmangel, the legal threshold for a travel defect? The court ruled no. The judge dismissed the case based on the legal expectation of self-help. Under this rule, if a problem can be fixed easily with minor manual effort, the traveler is legally obligated to fix it themselves to mitigate damages. Because the plaintiff failed to apply basic problem-solving to a minor inconvenience, he completely negated any legal right to a refund. The judge proved this by looking closely at the photographic evidence the plaintiff himself submitted. Beneath the mattresses, the beds sit on highly accessible, sturdy metal frames. The court outlined exactly how this should have been handled. The plaintiff simply needed to visit a local store and purchase a cheap piece of string. Taking just a few minutes, he could have solved the lateral sliding issue by wrapping that string tightly around the two metal frames. The legal barrier between a ruined getaway and a successful vacation was literally just a few minutes of manual labor and a piece of twine. But what about that first night? What if the couple didn't have string readily available the moment they discovered the beds? The judge had a flawless, indisputable emergency countermeasure ready. The plaintiff should have tied the beds together using his own trouser belt. As the ruling notes, the belt, quote, was certainly not needed in its original function at that moment. Travel law does not allow you to weaponize minor inconveniences for a payout. Before claiming a ruined vacation, the law expects you to utilize basic physical ingenuity and, if necessary, your own belt.